next matter will be people of the state of Michigan versus Lemmy Jones. However, not all the parties or attorneys are currently present. So for the live stream, I'll keep it going, but I will turn off video and mute until we have everyone here and ready to proceed. right, Mr. White, I think Mr. Dwayne is coming down to appear in person. I had everybody muted while we were waiting for everyone to get here, and I think he thought that was a problem with his audio. So I've been told he's headed down here.
All right, thanks, Judge. I will mute and be on standby here.
Yes, and we were waiting for the jail to get your client as well, so now he's here, but we'll
Okay.
wait. Here comes Mr. Dwayne. We can do it now.
All right.
This is People of the State of Michigan versus Lemmy Jones, docket number 21-110FJ. This is the time set for hearing on the defendant's motion for bond reduction. I think that might be more accurately stated as defendant's motion for a bond. I believe it's a no bond case right now. But in any event, Mr. White is here for the defendant, Mr. Jones, who's present. Mr. Dwayne for the people is here in person. If you could come up to the podium for purposes of this hearing, Mr. Dwayne, so everyone can see you. And as I indicated, this is the defendant's motion. Mr. White, you may go ahead.
Thank you, Your Honor. Oh, no, good. I'm not on mute. Thank you, Your Honor. Good morning. I filed this motion and generally speaking with motions, if they cover all the points I want to, I know the court has already reviewed these carefully. And so unless the court has questions of me, I will stand on my pleadings as written.
Okay, thank you. I have no questions. Mr. Dwayne?
I'll follow that up. And Judge, I did follow a response and listed the factors you must consider in MCR 6.106 paren F paren 1. I rely on my brief or my motion as well, Your Honor.
Okay.
Thank you.
Well, MCR 6.106C provides for release on personal recognizance when there's been a no bond for 90 days. I don't know if it's been 90 days, but in any event, the 90 days will be up. And so it's just as well that we have this motion. The court can determine that PR release is not appropriate if it will not reasonably ensure the defendant's appearance or it will present a danger to the public. I've considered the factors under the court rule, and I note that Mr. Jones has 3 prior juvenile adjudications, although it could be said that perhaps 2 are non-violent, non-assaultive. The 3rd one could possibly be, but I'll give it, I'll call it 3 non-violent juvenile adjudications. It is an undeniable fact that the Lansing Police Department fugitive team apprehended the defendant in Grand Rapids following these events. There is a history by the defendant of marijuana use 3 to 4 times a week with no known or none presented to me medical marijuana card. One of the factors that weighs very heavily in this case is availability of responsible members of the community who would monitor the defendant. I won't go into the details, but I have a family support services report that was prepared for the juvenile division. And the availability of responsible members who would monitor the defendant is completely lacking. I've also considered the seriousness of the offense charged. The defendant points out, as they always do, that there is a presumption of innocence, and that is certainly true. However, the court rules allow me to consider the seriousness of the offense charged. As a matter of fact, in a sense, they mandate it. The defendant is charged with 7 counts, open murder being one of them, and 4 counts of assault with intent to commit murder. As well as a couple of others. There are allegations that the defendant pulled up on a public street next to the victim's car, shot into the car over 10 times, killing a minor child and injuring the other passengers, including a 2-month-old baby. The prosecutor indicates that he has eyewitness testimony, video evidence, forensic evidence, circumstantial evidence, and a statement made by the defendant that's highly incriminating. Considering all of those factors, I am setting a $1 million cash or surety bond. And The next matter is the review hearing under the Juvenile Justice and Delinquency Prevention Act. And this is our approximate 30-day review on that matter. And Mr. White, did you wish to be heard on that?
Again, Your Honor, I will stand on the pleadings. He's been in the jail. He's conducted himself well, but based upon the court's ruling on the previous motion, I will just stand on my pleadings and await the court's determination.
All right, thank you. Mr. Duane, did the people wish to be heard?
Judge, I did attempt to contact Darren Southworth, who runs the jail. Was unable to get a hold of him today, but I have heard nothing as far as behavioral issues with Mr. Jones. I think all of his needs are being met. I think he is also probably attending some type of CATS program as well as any type of educational program. So at this time, I think it's in the best interest that he remain in the county jail. I do note that his birthday is coming up on June 7th.
Yes, I have considered the age of Mr. Jones, which, as the prosecutor has indicated, he is 17, but will be 18 in just a couple days over a month from now. I've considered the physical and mental maturity of Mr. Jones, his present mental state, whether he presents an imminent risk of harm to himself, the nature and the circumstances of the alleged offense, his history of prior delinquent acts, and the relative ability of the available adult and juvenile detention facilities to not only meet his specific needs, but also protect the safety of the public, as well as other detained youth. And I find at this time that there's been no change in circumstances. My previous findings are still applicable, and there are sufficient facts on the record that it is in the interest of justice to detain Mr. Jones in the Ingham County Jail. And I order that he shall be detained at the Ingham County Jail. And because this matter has to be reviewed every 30 days, I will conduct my last review hearing before he turns 18 on Monday, May 23rd at 3 o'clock. And if there's nothing further for the record, that will conclude this matter.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, appreciate it.